Okay, well, hello everyone, and welcome to March's webinar Wednesday, where I'm talking about changes that are coming in next month. And I wanted to do the April changes now rather than waiting to talk about them next month, because obviously there are things that we need to think about and processes and maybe some policy changes as well that we need to consider. So I think it's worth focusing on April now in terms of those employment legislative changes, and remembering, of course, that we've got that first, if I can call it, the sort of the big block of Employment Rights Act changes. Although we know that changes happened, didn't they, as soon as the act was passed in December, and then we saw some more changes as well in February, particularly around the sort of trade union changes. I'm not going to be covering those, but if anybody wants to talk about those separately, then of course I'm here to help with that. For those of you who are new, thank you so much for finding us. Thank you for joining us. And again, thank you to all of you who join me month after month to listen to and to, learn more about what's happening in the world of employment law, but also leadership as well. So for those of you who haven't had a chance yet to check out last month's webinar on how do you get people to do what you want, that was a really great opportunity to talk about, personality types and how they can impact upon leadership styles, and also how we can improve our communication as well. So do check out our YouTube channel and our website as well for those back catalogue episodes of Webinar Wednesday. For those of you who don't know me, I'm Emma O'Connor. I'm a partner here in our employment team at Dore Clayton, and I'm also head of client training, and lots of really exciting training courses that we're running at the moment for clients, whether that's on absence management. Train the trainer courses are really popular for HR teams, and also manager essentials courses. So those day-long courses for managers, really focusing on the things that managers need to know about, focusing on how they manage ER processes, how they can ensure that the way that they interact with their teams and the decisions that they make are compliant with the Equality Act, and also making sure that they are on board with all things ERA, because there's lots of things that we need our managers to do. So again, if you want to talk all things training, then please do get in touch with me and I'll send out information after the webinar. If you're new to Dore Clayton as well, we are a law firm that is based in Bristol. We are based in the Thames Valley and also in the city as well. And we support clients with a whole plethora of issues, whether that's HR support, litigation support, not just employment tribunal litigation, high court litigation, commercial litigation as well, corporate team as well, supporting clients with deals, and also our thriving EOT practice as well, employee ownership trust. So if you want to find out more about EOTs as well, get in touch. Specialist investigations, again, particularly when we think about sexual harassment and harassment investigations. And we have an interplay there often with our regulatory team as well. So again, do get in touch if we can help with all your workplace, commercial, corporate, pensions, data protection, education, and the list goes on. Really interested in looking at the questions that have come through in advance of today. First question, first person who registered. What are people doing about probation? What are people doing about probation? Yes, it's certainly something that is in the spotlight. And if you've not had an opportunity to join me or register and book on to our probation performance and procedure course, I would encourage you to do so. The course that I ran last week was brilliant, ran that in person in London. So again, thank you to all of those who came along to our London office. It was fantastic to see you all in person. I'm also giving you the opportunity to join that course virtually. I've still got a few spots that are available, so please do book on for that next Wednesday morning. The course is aimed at managers, but again, it's equally beneficial to HR colleagues as well. 2 hours, and also running this in-house. There is a real opportunity to look at not just how we onboard the new joiners, but also thinking about how effective are our probation periods. And again, with the eye always on the 1st of January 2027, do we need to think about reducing those periods of probation? It doesn't matter what you label your employee, if you label them as a fixed term employee or on probation, it's the length of service that is going to count. And that really is something to highlight and something to discuss. So, again, probation is under the spotlight. We can help with that with training. We can help with that with strategic discussions. And also, we've got a really nice probation toolkit as well that we've put together with a policy manager's guide, timeline, do's and don'ts, checklists. So again, please do get in touch about all things probation, but certainly it is something that we need to be looking at as part of our ERA strategy. So please do join me on that course or get in touch more generally. Again, if I had a pound for every time HR colleague would say to me, Emma, we need our managers to have these tough conversations. We need them to engage. We need them to really understand why having conversations about performance, about probation, about conduct, about strategy planning. We need managers to focus on that. So please do join me on the 15th of April, where I will be running a course on how do we tackle tough conversations, not just from a legal perspective, but from a practical perspective as well. I'm really excited to be joined by Debbie Harris of Represent, who's going to be running that course with me. So again, 15th of April, join me, 2 hours virtual. And again, lovely to see lots of you booking onto that course as well. So again, I'll be sending out details on how we can do that. And also we can run that in-house as well. And you know I love the masterclass. I know you love the masterclass. So again, 13th of May in London, 3rd of June, Reading, 10th of June, Bristol. We're in Bristol this year for the first time. Really excited about that. If you've got colleagues who are new to HR, maybe they've had a career break, maybe they want an HR refresher, maybe they are HR curious, again, please do book on to come and join me for that day-long course. So again, Masterclass 2026. Next webinar, doing a case law update, but again, I'll probably will just cover a recap about the April changes as well, because I know there is a lot of information out there, and I think it's really important that we just kind of keep reinforcing the message. If you've not yet listened to a DC Talks, please do so. 20-25 minutes, leadership, legal, HR hot topic. Last month's was on directors' duties. Really good discussion there with Julian Prentice, a partner in our commercial litigation team, and I've just recorded one on AI and HR uses of AI and sort of tips and traps. So again, do subscribe where you listen to your podcasts. I'm live today. This is recorded, so hello to all of you who are watching this on demand. It's a webinar. I'm not giving you legal advice. I'm just giving you a heads up into things that are changing. If you want HR advice, if you want legal support, please do get in touch with me separately. But again, this is just a heads up as to things that you should be thinking about, law changes that are coming out. But again, I'm not giving you any advice. Just to get that little bit of legal caveat over and done with. If you've not got a copy of the timeline and you've not laminated, you have not got it stuck on every wall in your office, let alone your house, then you need it. So message me and I will get that sent to you. So as we know, the Employment Rights Act really is huge. It's going to touch upon every aspect of recruiting, dismissing, managing, workforce planning, family rights, family entitlements, discrimination, harassment, sexual harassment. It really is going to be absolutely massive. But as we know, we've got this implementation timetable, so we can really break down what we need to do and when we need to do it, but always having an eye on what's coming up in the next tranche and the next block. So again, we're focusing on those April changes, and for today, that sort of block there. But again, let's have an eye on what's coming up. I think it's always good to do that. So again, if you've not got a copy of the timeline, let me know. We can get that over to you. And again, if you've not had a recent copy of the timeline, again, because it has changed with what the government have been up to as well, with sort of tweaking things and changing things as well. So again, please let me know and we can get that. What I would say is some of those latter changes, so maybe some of the 2026 changes might creep in. We've already seen fire and rehire, haven't we? Shift from 26 to 27. Possibly the increase in employment tribunal litigation timelines, that 3 to 6 months, that limitation period, we may well see that creep into 2027. So again, this is really something to watch, keep an eye on, but we will be keeping you updated, whether that's through our webinars. So please keep signing up to the webinars, whether that's through our newsletters, podcasts. So again, if you are not subscribed, you need to be. So again, please do subscribe. And again, I'll be sending out information about how you can do that. Points to note, as ever, as I've told you, this is a webinar, I'm not giving you legal advice. The other thing to say is that some of the big changes, they are going to be the subject of consultation. So what we are seeing at the moment, we've got consultation out on flexible working, fire and rehire, collective consultation triggers. So we've got consultation that is out there. So again, there is some of the detail that we don't necessarily know about, but again, it's just something to kind of bear in mind when you're doing your strategic planning. So again, stay tuned, to us. We will be updating you as we go through. So April, what isn't going on in April? So yeah, no, brilliant. Thank you so much. We'll get all those timelines sent out. So April 2026, we know, don't we, that April is traditionally that year when stuff happens in employment law. And so we're kind of geared up for it. Tends to be more kind of the monetary changes, so the SMP rates, a week's pay, the compensation rate for unfair dismissal, our last one. That's going to change as well. So we're sort of geared up for it. But obviously, this April, we've got other things that are happening, Employment Rights Act related as well. So let's talk about what some of those April changes are going to be, and let's focus on what we need to do and how we can get April ready. So kicking off with a big one, although I've run out of wow words, as my children would say, to describe how big, huge, massive a lot of these changes are. So if you've got any more wow words, please let me know. But I think the first one we're kicking off with is a big one, and it really is going to impact those organisations that are looking at, those big redundancies and factoring in the cost and the risks associated with that. So we know we've got some potential trigger changes, and there's some consultation out on that at the moment. So the establishment test will stay, but it's going to be one establishment, or looking at the numbers of redundancies that you're making within that 90-day period across the whole workforce. So again, please, something to watch, as we move forward into 2027. And what that will mean is that those smaller pockets of redundancies, maybe the 10s or the 15s that don't hit that 20 at one establishment, could well be sucked into collective consultation when we've got those additional trigger points. So again, really something to focus on in the HR team, making sure that you've got those processes in place to really have a handle on what is going on in different parts of the business. But for these purposes, for April purposes, that protective award claim. So that's the claim that affected employees can make if the employer has not complied with those collective redundancy consultation obligations. And remembering the definition of redundancy under TOLRECA is slightly wider, not just redundancies, but can also apply if you're making changes to terms and conditions of employment. So we've got that shift there, that change in the protective award claim, currently 90 days, but that's going to increase to, up to 180 days actual pay. It really is going to bite. So again, factoring that into your planning, factoring that into your timetabling. So again, really need to focus on that, and also raising the issue with managers, senior leadership, boards, so that they understand that actually the process of making redundancies is going to become more complicated when we've got those triggers that are coming in 2027. Query, do we need to be thinking about things now? But also that general risk assessing that we need to go through, and remembering, of course, there that we've got that increase in protective award per affected employee. So again, big changes then, big potential risk and costs there if we get things wrong. So kicking off with a big E. Also, what we are going to see, and again, we're going to see this throughout 2026 and then again in 2027, we've got some family right changes and some family leave changes and increase enhanced protection that we're going to see coming out later on in the implementation timetable, protecting, we think at the moment, just pregnant women, maternity leave and maternity leave returners. But again, we might see some sort of change and flex on that. But for the purposes of today's webinar and looking at these April changes, we need to focus on, well, two key changes there to paternity leave and also to unpaid parental leave, and the qualification period of service that we currently have for both of those types of leave will obviously be removed. So those will become day one rights. So the entitlement to take the leave will be a day one right. What is not changing is that pay point. So parental leave will continue to be unpaid, and paternity leave, again, we're going to have to hit that service qualification trigger and eligibility criteria triggers to be able to qualify for statutory paternity pay. We're also going to see this kind of weird anomaly between shared parental leave and paternity leave, and when you can take it, and you know, you can't take paternity leave if you've taken shared parental leave. So we're going to see that actually being removed, and that makes sense. To do that. So again, we're going to see that anomaly change, but we will need to obviously go back, revisit those of you that do have shared parental leave policies, those that have policies on paternity leave and also parental leave. We're going to have to go back and revisit those. So again, you know, shout out if we can help with that. And then we've got this bereaved partner's paternity leave, which has sort of been kicking around for a while, and sort of slipped in a little bit maybe under the radar just before Christmas, because obviously we were focusing on, you know, will the ERA pass, you know, will it, won't it? We're in our sort of parliamentary ping pong land. So bereaved partners paternity leave. Now, this is one, and again, it's one of those sort of areas which is, you know, very sad and difficult sometimes to discuss, but obviously we're looking at if a partner or mother has primary adopter has passed within the first 12 months of either the baby being born or the child being passed with adoption for adoption. That's going to be the ability for partners, fathers, to be able to take up to 52 weeks of unpaid leave. And again, so that leave is unpaid. Something to think about, you know, something to think how we're going to manage that, particularly within the business setting. So again, something to look out for. That's a new right that's coming in from April of this year. So look at your systems, awareness as well. So making sure managers are aware of these changes that are coming in, that they might get asked from day one to take paternity leave. And again, looking at our policies as well. So we need to just have some awareness of those changes that are coming in. Sickness absence is a big area for lots of businesses. And now for many of you, you may not have a system where you only pay SSP. You may be looking at paying some enhanced sick pay from the first day of leave or the first day of sickness absence. So for many of you, this change may not make an impact. Also, the fact, you know, the earnings of your people, the earnings of your staff may mean that actually this change may not be of much consequence. But actually, there are a lot of organisations out there that will look to pay SSP and SSP only, certainly for the first, you know, for basically as it stands now, looking at the waiting days. So this change to SSP is actually going to have a big impact. The other point to remember about SSP, of course, is that it's a business expense. It's not one that you can reclaim. So I would also be thinking about making sure that in your policies you're very, very clear that if you do enhance sick pay, that any sick pay that you do pay, it obviously includes SSP. So what's the change? Well, the change is going to be that from the 6th of April, we are going to basically do away with the current waiting day system, which is that SSP, statutory sick pay, is not paid until the fourth day of absence. So essentially, you've got to be off sick for that length of time before you qualify for statutory sick pay. The other point to note at the moment is we've got that lower earnings limit, that LEL, that applies to statutory sick pay. So if you earn less than the current lower earnings limit, you don't qualify for SSP. Now, part of the government's big plan, as we know, in the sort of, making work pay, was wanting to support individuals who are unwell and encouraging them to be, get better rather than feeling that they had to return to work. So what the new rate of SSP is going to be is either you qualify for SSP or depending on what your earnings are over an 8-week period, you may qualify for 80% of your earnings up to obviously the flat rate of SSP. Now, most of you will have payroll providers or you'll have payroll teams that will be, aware of this. I just want to sort of flag, because I can see maybe getting a little bit muddled. It's 80% of average earnings, not 80% of SSP, because I think there might be a little bit of confusion over that. And of course, remembering that SSP it does, potentially have that wider remit, not just employees, could potentially apply to, casual staff as well. So as I said, for most employers, this won't impact, because what individuals will be earning over the week will be more than what the SSP rate is anyway. So, we won't need to go through these calculations. But for some of you it will have an impact. So again, we're looking very much at those average earnings again over an 8-week period, and then thinking about how we calculate what those average earnings is, remembering of course that you only earn either 80% or the flat rate of SSP. That's the rate. So again, we need to be thinking about that. And yet, it might be something that we need to communicate. We need to look at obviously our policies on sickness, absence, and sick pay. I also think it's a really, really good time to think about absence management and how we are encouraging better absence management within the organisation. So I think communication, setting those expectations, what are your notification provisions? Are people tracking sickness? Are your managers actually aware of who's off sick, why they're off sick? So just some SSP what ifs. Same principle around the linked periods of sickness absence, they still apply. Remembering SSP is a business cost. So again, I think there's a real, as I've said, that opportunity to check processes, policies. What do we say in our contracts? Do we need to update those as well? I think expectation setting and monitoring of absence, knowing where your triggers are, is really, really key to all of this. Also, just to remember as well that this applies bang on 6th of April. So we can't wait if somebody's on like day 2 of the waiting day. You don't wait till day 4. They are entitled to be paid it from the 6th of April. So again, making sure we've got those processes in place to really check to ensure that we are compliant as of the 6th of April as well. And remembering as well, it's that 80% of earnings or the lower rate of SSP. Notification provisions aren't changing, so it's still obviously doctor's note and self-certificate. And again, return to work interviews, self-certificate forms. Are we really, on top of that as an organisation? Really, really key to absence management. So again, training, awareness, policies, contracts, all of that good stuff. And again, making sure that your payroll and also your in-house payroll teams are aware of those changes, and they change on the 6th of April. Entitlement changes as of the 6th of April. Let me just have a look, see, we've had a couple of questions on that. Yeah, so it might be something we need to think about. Yes, I think, wider communication. Use it as a reset as well. I've got a lot of clients who are using it as an opportunity to train managers, look at policies, look at processes, and reset. The rules are changing. So let's also think about how we can reset how we do things. Are you clear that, people have to fill out self-certificate forms? Are we checking? Are we monitoring when people are off? So again, use it as an opportunity, I think, to kind of engage people in sickness absence monitoring processes, and also resetting those expectations. So sickness absence, SSP, again, for a lot of you, it won't impact. But again, I do think for a number of employers out there, particularly, those of you who maybe have a lot of sickness absence, you only pay SSP, it's one thing, it's going to be a business cost. So again, make the business aware, but also what can we do to support and tackle, make sure we've got really good absence management processes that support employees who need it, but also that we've got, checks and balances in there as well. We've also got some other changes as well that we need to think about from April. We're going to have a big spotlight, aren't we, on sexual harassment and harassment. We know we've got some October changes that we need to be thinking about. One change that's coming in from April, now, raising concerns about sexual harassment in the workplace is going to become what we call a protected disclosure. So an individual will be able, once they've raised a genuine whistleblowing complaint, will be in that category of a protected individual. Remembering as well that that there's no service qualification if you dismiss an individual, an employee, because they have blown the whistle. That's an automatic unfair dismissal as it stays now. So again, we need to look at our whistleblowing processes. We need to look at our whistleblowing procedures, and also really be clear, do we have the mechanisms in place for individuals to be able to raise concerns? And that's part of our preventative duty as well, not just under whistleblowing. So again, opportunity there to have a really look at our whistleblowing procedures more generally as well. NDA settlement agreements, we don't know when this is coming in at the moment, but certainly looking at what do our NDA settlement agreements say about restricting individuals' rights to raise concerns once that settlement agreement, that NDA, is signed. Fair Work Agency, I mean, and we've got this new government body that's going to be taking on some, consolidating some agencies currently standing, thinking around, hours of work, gangmasters. And again, we might see those powers increase as, the Fair Work Agency, gathers momentum and potentially gathers more power. So again, that's going to be set up from the 7th of April. So something to watch out for, I think. And again, we've got some trade union changes. We're going to see trade union changes pretty much from 2025 to 2027. So again, stages of implementation there. So, and again, bit of a change there. That we saw when the government in January produced a new timetable, a new implementation timetable, looking at e-balloting, and we had August pop up as a new date when things are going to happen. So again, that will be relevant to some of my audience. Okay, so let's have a look at some of the other changes that are going to be happening. So non-ERA change, but again, it's one that we're used to seeing. So thinking about national living wage, national minimum wage as well. SSP is going up to £123.25 a week. SMP, I've put etc. because, it's SMP, SAP, SPP. So all of those sort of, family leave rights that have an accompanying statutory rate of pay, again, that is going up. What we don't know, and I'm going to have to really caveat this. So what I don't know at 12:30 on Wednesday, the 18th of March, unless I've had an update in the meantime, I can't tell you, unfortunately, what a week's pay is going to be, or what the, grab your hankies, what the last increase will be for the unfair dismissal compensatory cap. Hasn't been announced. Interesting. Normally comes out end of February, but so I'm caveating that as at 12:30 on Wednesday, the 18th of March, I don't know what it is. So if there's been an update whilst I'm talking, then please pop it in the chat. So we await that one there. Everyone's favorite gender pay gap time. For those of you who are caught by the gender pay gap, reporting obligations, and some of you aren't. I know lots of employers that actually voluntarily review their pay gaps because actually it's a really good thing to know. Where are we? We might tip over into the larger employer definition. So actually it's good to be on the front foot with these conversations. So again, snapshot dates, something to be aware of as well. Always remember we were looking back, but we're reporting a year. So 2025, we're looking at 2026 to report. But actually, gender pay gap reporting and also menopause equality action plans are actually something that businesses can start to think about now. So they are voluntary from April of this year, but they will be mandatory from the spring of 2027. The government have said. The government have issued some guidance, so well worth having a look at. I think even if just to get, being, prepared if you're going to be caught. And what the government are hoping is that they will use 2026, 2027 as, and I quote, a practice year ahead of mandatory reporting. Again, mandatory reporting, but at the moment, the penalties are, the court of public opinion, employees, reputation. So, what are equality action plans and menopause action plans? Well, I would encourage you to go and look at the government guidance. And again, if you want me to send that to you, I'm happy to do so. But effectively, what the government are saying is that they have produced a list of things that they would consider to be evidence-based. And what they are expecting is that employers will take on board at least one of the action plans in respect of equality action plans and to reduce the gender pay gap, and also to another, at least one of the action plans with regards to supporting employees who are experiencing not just menopause symptoms, but perimenopause as well. Wanting employers to track that progress. Where are we now? What do we want to do? And again, monitoring the effectiveness of those steps that you're putting in place. So employers to track and report progress against those chosen actions. I'm expecting that obviously we've got this, voluntary period of time now, but again, we expect those reports, those mandatory reports, to be published in April of 2028. So what actions? Again, the government have produced some guidance on that. It's going to be around looking at recruitment processes, looking at job descriptions, how inclusive are our processes, again, diversity in senior roles, general transparency over pay. What support are you giving to staff? So whether that's through, adjustments, policy updates, training, access to EAP, access to occupational health. And again, not just what we're doing, but really analysing what we're doing. Is it making a difference? Is it actually achieving what we want it to achieve? So again, workforce, reviewing the workforce, engage with your staff, have a staff survey. What does staff, want? And again, encourage that collective approach. And again, raising awareness with managers, with management about what these obligations might look like and the things that we can do, should be doing, and again, the effectiveness of those. So again, something to really look at. We'll talk about it more in the autumn when obviously we're going to see some of the changes coming into effect in 2027. But again, something to have on the radar now, I think. So just in the last few moments of today's webinar, again, thinking about where are those opportunities? What do we need to be doing? And I think, what I'm working with clients on a lot is really around that strategic implementation. We know what's coming roughly. All right, there might be a bit of kind of tweaky bits 2027, but we know roughly what's happening, secondary legislation aside. So I'm working with clients now to really focus on strategically what can we do, when we should be doing it, and how we can, make sure that we are ERA ready. I've talked about some of these in our discussion, but again, managing sickness absence. Ran a train the trainer session for a client this week actually, for their HR team, which will then enable them to support managers in how they manage sickness absence across the business. So again, training, awareness, policies, reinforcing those expectations. What are the triggers? Short term, long term, let's really focus on making sure that we are using those tools that we have at our disposal more effectively. Contracts, policies, again, this, I've been talking about this for a long time now. Are there things that we need to be thinking about now, again, with an eye on fire and rehire? The ability for employers to make those changes to contracts is going to become more difficult from 2027 onwards, January 2027. So again, what can we be thinking about and looking at now? So again, please do get in touch if that's something that you want to talk about strategically, and again, how we here at Door Clayton can help you. Workforce planning, where are you? Who is working for you? In what capacity? Training, not just on absence management, not just on probation, but ER processes more generally. I'm running lots of updates for senior leadership teams, boards, managers on exactly what the ERA is. Let's start with a bit of baseline here, and then we can look at doing some sort of more targeted training, targeted support around that with toolkits. And again, making sure that managers have awareness, but also they've got that support around them to enable them to, again, do the things that we want you to do. And I would encourage you to think about that Tackling Tough Conversations course as well, a really, really good one. We need to look at our family policies. Do we need to tweak those? Do we need to update paternity, obviously parental leave? Do we need to think further ahead around flexible working changes as well that we've got coming in later on in the timetable? But again, greater protection means greater awareness, and particularly for our managers as well, so they don't say the wrong thing at the wrong time. Culture and engagement. Again, this is a really nice opportunity to think about, not just the sort of targeted work that we need to be doing around third-party harassment, and obviously the preventative duty there from October around the all reasonable steps duty, but really thinking about what does that mean culturally? Again, gender equality, we've got the menopause action planning. Is there something that we can do as a wider conversation? Again, really thinking about with an eye on October and what those changes are going to mean. Have we got our risk assessments? Have we refreshed our training for managers? Is it targeted training? Is it specific? Is it really thinking about who we are as an organization and our risk profile? And again, for regulated clients out there, again, thinking about, do we need to think about FCA rules and non-financial misconduct as well, and what that means? So again, please do get in touch with me. The plan is with the webinars is that we will look at October and thinking about 2027. I'm going to start doing that from September. So again, we've got that nice lead in, because I appreciate there's a lot going on. We've got our overview. We know what's happening. We know when, but now let's really focus on the targeted information and the real strategic work that needs to be done. Let's do that compliance sweep. So again, do think about, again, joining me again as we move into the autumn. So on the horizon, sexual harassment changes. We know from 2027 we've got that change, a huge change to unfair dismissal qualification. Remembering as well, it does not matter the label. We are just looking at how much service does that employee have. Ending of a fixed term contract is a dismissal. All of those conversations around fixed term contracts, probation, early employment, all of those things are going to be very, very important. And again, remembering, that removal of the compensation cap that we know is going to happen from the 1st of January. But what we don't know at the moment is to which type of claim that's going to apply to. Will it apply to just dismissals, on or after the 1st of January? Might it apply to, claims that are in the tribunal? So again, just have that, in the back of your mind at the moment. So we're waiting for some more clarity on that. Fire and rehire, I've talked about from 2027. 0 hours, low hours workers. It's going to be incredibly complicated. So again, let's start thinking about who's working for us now and how and in what capacity. Some pregnancy dismissal changes coming up, consultation on that. It's looking quite tricky, actually. So again, we just need to have a focus on it. And again, the flexible working changes that we've got. And, as we know, we've got umbrella companies, we've got tipping changes, we've got trade union changes as well. So what does that look like, particularly around the access to work, and what information do we need to be giving staff around that ability to join a union? Waiting for obviously clarity on that at the moment. But let's just have that wider picture. But again, let's really focus strategically on what we need to do. Get in touch with me, whether to talk about strategic support, toolkits, policy changes, contracts, and obviously kind of the wider information piece as well, whether that's train the trainer or looking at how we manage probation or longer courses for managers. I'll send you some details of how you can do that as well. Remember to subscribe, stay in touch. We've got lots of good things happening, lots of support that we're giving to clients. So if you'd like to hear more about how we can help you and how particularly we can help you with strategic planning, then please do get in touch. We've put obviously the links of how you can find out more about webinars and podcasts as well. So again, please do get in touch with me if we can do that. Couple of questions around SSP. I'll come back to you separately on that. So again, we do need to be thinking about sickness absence, sickness management, because again, it's part of that tools, isn't it? Use the tools that you have at your disposal to support the individual, to give them that that real kind of, help, when they need it. So until next time, I will see you again, obviously, on the next webinar. I hope to see lots of you booking up to that course next week that we're running virtually on probation. And again, please do look out for that 15th of April, Tackling Tough Conversations. And also we can run that in-house. So thank you so much. We've had amazing people, the numbers of joining us today. This is fantastic. So thank you so much for joining me and getting in touch with the conversation as well. Lots to do. But again, we're here to help and support you. So please do stay in touch. And I look forward to seeing all of you very, very soon. All the best. Bye-bye.